Mr. Clark, do we have any preliminary matters?
No, Your Honor.
All right, call the first case, please.
Jamesway Construction, Inc. versus David W. Salyers, P.E.
Mr. Chief Justice, and may it please the court, my name is Harrison Kilgore with the Tennessee Attorney General's Office. I would ask to reserve 6 minutes for rebuttal.
All right.
This court initially granted review in this case to explain the role that uncodified law plays in statutory interpretation in order to resolve a disputed deadline for appealing initial ALJ orders for the Board of Water Quality, Oil, and Gas. Unfortunately, this court lacks authority to provide answers to those important questions because the Chancery Court lacked subject matter jurisdiction over Jamesway's petition for review. The parties agree that Section 45322A1, which grants Chancery Court's subject matter jurisdiction over interlocutory appeals only if review of a final agency decision would not provide an adequate remedy, is the jurisdictional touchstone here. And the parties agree that party agreement, waiver, or forfeiture cannot satisfy that requirement. So the remaining question is whether judicial review of a board decision here would provide adequate relief to Jamesway, and it would. On judicial review of a final board decision, Jamesway could bring an identical challenge to the board's authority over TDEC's appeal, raise the same theories articulated here, and obtain the same relief that Jamesway seeks now.
Mr. Kilgore, how do you read the phrase adequate remedy? What does that mean in your view?
I think adequacy bakes into it some considerations, and I, of course, have recognized that it is a fact-dependent inquiry, and so I think that it's very tough to lend itself to a definitive single rule, unified rule, but I do think that there's a spectrum, and I think that this case sits at the end of the spectrum that's very easy to decide, because in a case where a petitioner can obtain the same relief that they are seeking on an interlocutory basis on final review, and they have not articulated any form of irreparable harm that would otherwise befall them, I think that that is an adequate remedy. I think on the other end of the spectrum, where you would have an inadequate remedy, would be pointing you to the Excalibur case, or to an instance in which a administrative agency has ordered someone to turn over privileged documents, or to, if there's a claim of immunity at the administrative level. I think in both of those instances, once the immunity has been denied, or once the privileged material has been turned over, there's no way to unring that bell. And so upon final review, or review of a final agency decision, there's no way to actually remedy the issue that was decided below.
Do you think, so, I mean, when you look at that language, adequate remedy, is it the sort of thing where you just look up the dictionary definition of adequate, and then you look up the dictionary definition of remedy, and then you just, combine the two? Or is adequate remedy, I mean, is that a legal term of art that kind of finds its meaning and, more of a historical understanding of that phrase?
I think that it's more the latter, and as I was trying to think through this question, I would point the court towards some of its jurisprudence related to the mootness doctrine, where it has to evaluate whether or not, upon subsequent developments in the case, whether or not there's still an ability to afford judicial relief. And so there's still, in that inquiry, this court has said that you have to bake in considerations of fact-specific, independent, case-specific facts to determine whether or not judicial relief can be afforded. And I think here, determining whether or not there's an adequate remedy for the petitioner, again, bakes in those case-specific facts.
Mr. Kilgore, I'm sorry. Mr. Kilgore, certainly there may be a remedy, but it must be an adequate remedy, right? And doesn't the Excalibur case teach us that there should be a broader view of the implications of the harm that may result that needs to be remedied? For example, in Excalibur, the court discussed uniformity of decision. In Excalibur, the court discussed the interests of judicial economy. In Excalibur, the court was interested in the impact that the decision would have on other cases. So I'm curious, you cited Excalibur. Doesn't Excalibur broaden that spectrum that you were talking about?
I don't think so. I think Excalibur is informative in the fact that, again, case-specific facts play into it, but I think a lot of the case-specific facts that were present in Excalibur are not present here. So, for example, there's no opportunity in this case, there should be no fear that on judicial review of a final agency decision that there would be any retrial, for example. In this case, if upon remand to the agency, there's an unfavorable decision for Jamesway, they would be able to seek judicial review, and if they are successful in judicial review, they would have complete relief in the relief that they sought, and there would be no retrial, because at that point, the September 22nd order of the initial order of the ALJ in this case would be final, and Jamesway would have the relief that it wanted. So I agree that Excalibur informs the court's inquiry in terms of that there are specific case-specific facts that play into the adequacy of a remedy, but I just don't think that Jamesway in this case has been able to articulate any of the case-specific facts that would lend itself towards an inadequate remedy here.
Well, the facts of this case are pretty straightforward, right? I mean, but let's talk about, if we might, this concept of adequacy for a moment. Should we consider uniformity? In this case, you had the board making one finding, the trial judge making another, the Court of Appeals making another, 2-1. Is that something that we should consider in determining whether we should exercise our subject matter jurisdiction in this case, or no?
I'm not sure that the consistency of the decisions within the case itself should play into it, because it's whether or not the petitioner can obtain an adequate remedy. So the question is whether or not the petitioner is ultimately able to obtain a remedy that is satisfactory towards the petitioner. I think that's why in the Excalibur case, the concern was the petitioner on judicial review of a final agency decision, there would be no way really for a court to determine what the absence of evidence upon the denial of discovery in that case, how that would have played out in the decision-making process. Versus here, you have a clean statutory question. That is the bread and butter work of the courts, is going through de novo. I should also point that out, that it's de novo review in this case on review of a final agency decision. So I would push back against the idea that inconsistency or disputes about the specific case or the specific issue within the case should play into the adequacy question. I think it's more important to give credit to the fact that upon review of the final agency decision, the court would have de novo review of that.
What about the impact on other cases?
I think, again, the primary concern should be about whether or not the remedy is adequate as to the petitioner. I think the court could find that, I point you to the Mosley case, for example, where there are multiple cases that are raising the same issue. I think that would be a closer case, but I still think that the primary concern should be whether or not the petitioner in this particular case can obtain a remedy that is adequate for them.
I'm
Go
sorry,
ahead. No, go ahead.
Mr. Kilgore, let's talk about that remedy then for a moment. What is your position as to what remedy Jamesway could receive if this case were to proceed as is, and this court finds that there's subject matter jurisdiction in this instance, is number one. Then number two, if it does not, and it goes back to the board, and ultimately you say the board can give them the relief they want, what remedy would the board give them?
So to be clear, I guess I'll try to take that in two parts. I just want to clarify the second part. In terms of whether or not the board can give them relief, that, as we've argued in our briefing, is not what is contemplated under the statute. It's whether or not the court can afford them the adequate relief. And I think in both instances, it's identical relief. If this court finds that it has subject matter jurisdiction and it disagrees with us on the merits, then it would cancel out the TDEC's appeal, and the September 22nd initial order of the ALJ would become final and determinative of Jamesway's penalty. And I think similarly, if on remand, we go through the entire process before the board, assuming there's a adverse decision against Jamesway, and they take this case back up, and ultimately the court finds that the 15-day deadline applies, and therefore the board lacked jurisdiction in the first instance, it would be void ab initio. And therefore, again, Jamesway would have the September 22nd initial order of the ALJ would be final and determinative of its penalty in this case. So I think, again, that there's a spectrum on what qualifies as adequate, and I think that this case falls at the far end of where the petitioner does have an adequate remedy.
So how much do we consider whether they are deprived of the specific remedy associated with the deadlines at issue? There's global look at the entire case. Would you be able to go through the entire administrative proceeding, get to the end, have judicial review, and then go back and look at the deadline issue? There's that you would be able to do, but the purpose of a deadline, of enforcing a deadline, is that they would not have to go through that. And similarly, we have a similar concept, for example, in arbitration clauses, where the real issue and the focus of that, the statute here, is if the deadline has passed, then they wouldn't have to go through the entire proceeding. How much do we take that into account?
I think the better touchstone and the better guiding light is the ultimate relief that is sought. And I think Hyundai is instructive on this point, having to go
Of course,
through.
you understand we're not bound by
It's purely instructive, but I think that I think it's instructive in that it recognizes that if purely having to go through the administrative process was enough, then basically that opens the door for any kind of interlocutory appeal, having to expend the time and resources back at.
I'm going to push back on that. It's maybe not any interlocutory appeal. I'm talking about where the issue relates to deadlines that are outcome determinative, and whether anybody's going to have to go through the proceeding at all.
And I appreciate and respect that pushback as well, Justice Kirby. I guess then, so that to the second point, to the extent that Hyundai is only instructive, I also think that the doctrine that has built up around interlocutory appeals of denials of jurisdiction generally is instructive, because in that case, when lower courts deny a motion to dismiss for jurisdictional purposes, there is no immediate appeal as of right, even though they're outcome determinative, and it would force the parties to continue to expend time and resources. So I think to the extent that Hyundai is obviously not binding, I think that those two things combine to assuage your concerns on that front.
I'm a bit confused. I'm sorry to interrupt you. In following up on Justice Kirby's question, is the state taking the position that we should apply the same rules that we do to interlocutory appeals to this agency decision?
No, sir. No, what I was trying to convey was that simply
You're saying the opposite, that it's not just a permissive interlocutory appeal.
Correct. I still think that the court has to independently assess the adequacy, and I think that in doing so, those types of cases are instructive, that purely because it's an outcome determinative issue does not compel allowing petitions for review to be filed under this statute.
Does Mr. Kilgore, does the collateral order doctrine have any relevance here?
I think that it's instructive in terms of determining whether the instances in which a appeal would be inadequate. So I think collateral orders in the federal court typically point to sovereign immunity type cases or privilege, which are the two types of cases that I've identified that I think are at the other end of the spectrum, in which there would not be an adequate remedy at that point, because again, the bell has been rung and it can't be unrung. And I guess I keep returning that I think that this case is very distinct because you have an instance in which Jamesway can obtain identical relief through an identical challenge, raising identical issues on final review versus, so there's really no need for for an interlocutory posture to take place.
And so really that, the only, I guess, cost is just delay, that they would prefer to have a decision, a final judicial decision a little bit more quickly and not kind of have to go through the whole process. But how do you see, so, you mentioned sovereign immunity, for example, in the collateral order context. I mean, how, in your view, is this different? I mean, both have to do with, to some degree at least, with, not kind of having to go through that process. So is it different here just because we're not dealing with an immunity defense and, it's not the case that the jurisdictional statute was intended to kind of protect the aggrieved party from the burdens of going through the agency review process? Is that what you see as the key difference?
Yeah, I think that that's certainly the case. I represent the state, and I think sovereign immunity is a very distinct doctrine. Sovereign immunity is an immunity from suit, and it prevents you from having to even go through the rigors, versus I think that the collateral order doctrine and some of this court's jurisprudence around interlocutory appeals related to motions to dismiss have demonstrated that that's different in a purely jurisdictional context. I think that when a party has an immunity from suit, that is a distinct situation.
So if and I guess it's a little hard to ask this question in the agency review context, because I guess in that context, immunity has been waived, but let's just
Right.
hypothetically,
Correct.
if you did have some sort of immunity, defense here, your position would be that immediate review would be necessary to provide an adequate remedy in that situation?
So I think my memory is that my office recently filed a brief in a case related to an immunity doctrine related to religious issues. And I think, for example, if a religious entity were going through some form of administrative proceedings and they invoked that form of immunity, I think that we would take a very different position in terms of the adequacy of the remedy that they could receive on review of the final agency decision.
Mr. Kilgore, my question relates to the mission of the agency. Should we consider the mission of the agency in determining whether there's an adequate remedy? Surely the state doesn't take the position that precluding a remedy would not frustrate the mission of the agency. Is the mission of the agency something we should consider at all in determining the adequacy of the remedy?
I think in instances, particularly where the agency itself is the one seeking some form of interlocutory appeal, I think that would be akin to, the frustration of the mission would be akin to an irreparable harm, which courts have recognized previously fall within the adequacy inquiry. So I think that is fair. I think, again, this is not that case because Jamesway has not articulated any kind of frustration of the mission of the agency in this case that couldn't be remedied on a final agency.
Okay, and should an equal consideration then apply to the adverse party like Jamesway?
I think if Jamesway were, I think one of the reasons that this case is so, in our opinion, is so easy is because not only do we have the up and down identical relief, but there's also been no articulation of any kind of irreparable harm that would befall Jamesway. So I think if Jamesway were able to identify irreparable harms that it would suffer if it were forced to go through a final review of a final agency decision, and that I think is, I would point you back to Excalibur, where they identified if we're forced to go through a review of the final agency decision, we're going to have to be delisted, and we're going to have to suffer reputational harms. And the court didn't ultimately find this. I believe that this was waived, but they also identified other statutes in other states where they might be delisted from the tobacco registries in those states as well.
But doesn't that bring us back to Justice Campbell's original question? do you have to show irreparable injury in order to meet the standard of not having an adequate remedy? Is that how we should interpret it? Or is it, do we simply assess the level of harm that's visited upon the party that is seeking permission to appeal?
I do think that the inquiry can go beyond irreparable harm, that there are other factors, but I think that irreparable harm has been recognized by the courts as a particularly influential determination as to whether, or factor.
I think all of us would agree if there was irreparable harm, the remedy is not adequate. The question is then, how do you articulate, if we go beyond that, how should that be articulated? How would you suggest a limiting principle?
Yeah, and I think I started off with saying that because adequacy bakes in some of these equitable considerations that we've been discussing, it's very difficult to craft a single unified rule. I think what would be the better course in this case and generally is to develop through common law decision-making, but to decide in this case that where the petitioner can obtain the same identical relief through an identical challenge, raising identical issues upon de novo review of a final agency decision, that is adequate. And I think really that's not so narrow, because I think that if the court had given that instruction, I think that both applied underwriters and Hyundai would have been like 3-page cases.
Mr. Kildor, I don't want to, if my colleagues have other questions about jurisdiction, I can wait on my, I did want to
Ready
turn
to
to the
move on.
merits.
Go ahead.
Okay,
Go
we're
ahead.
ready to move on. I do want to touch on the merits at least a bit. I'm trying to make sure that I understand the codification process, and in particular, kind of what happens after the codification. After it's decided what is going to be codified or not codified. And I have a question. This was not in the briefs, and so you may not be prepared for this, and that's okay. But I do want to ask you so that if you are aware of it, you can help enlighten me. There's a provision in the Tennessee Code. It's 12114 that is it's about reenactment of statutes, public acts, the portions of which have been codified. And the way I read that statute, I think the way I read it, it suggests that everything that has been, where it has been determined that it should be codified, is kind of reenacted, so that the codified parts of the law are the law, and I guess everything that was not codified gets hits the cutting room floor. And there's a part of this, subsection 3 of this statute says clauses, preambles, captions, statements of legislative intent, severability or reverse severability clauses omitted from codification pursuant to section 11108 remain valid in construing legislative intent of the codified portions of the act, notwithstanding that the omitted portions of the act were not codified. So long question. This was not in the briefing, but I'm wondering if you are aware of this provision, and if so, if you can help me understand how this might impact your arguments about what is and is not law.
I do apologize that I'm not prepared on 114. I will say it sounds to me, as you read back the subsection 3, that in the worst case scenario, section 19 of the 2013 Public Water Act would still have some role, to the extent that it is an uncodified statement of intent. It can help the court determining the General Assembly's intent in codifying, let me circle back. It would help determine the General Assembly's intent as to how the 30-day deadline would interact with the 15-day deadline. And because I'm short on time, I think the most important thing, something that was not acknowledged by the majority below, and that my friends on the other side have not acknowledged, is if section 19 is not considered, it excises and renders totally null an entire sentence of section 110A. But if section 19 is considered, then it reconciles the entire statute such that all of section 110A is applicable, and the 15-day deadline continues to apply in every other situation that's not the Water Act. And the construction of law provisions continue to govern, such that if, for example, there were any discrepancy between the rulemaking provisions of the Water Act and the UAPA would still control in those instances.
Okay, let's wrap up, Mr. Kilgore.
I have 6 minutes on rebuttal, so thank you.
Good afternoon, Your Honors. My name is Autumn Gentry of the Nashville Bar, and Patrick Clark and I are here today representing Jamesway Construction in this appeal. I'm sure the court has a lot of questions to ask, and I don't want to go back and summarize the facts of the case, because I think just from the questions you've already asked, it seems like the court is pretty clear on how we got here. But this case is about the state violating specific statutory provisions, exceedance of agent's authority by appealing a final order, which is all rooted in TDEC's untimely appeal.
Ms. Gentry, now would be a really good time for you to tell us why final agency review in this case would not provide your client with an adequate remedy.
Sure. And we've listed several factors. One is that, this case has dragged on for 7 years. We're talking about and we haven't even gotten to a trial on the underlying issue, but it's taken 7 years just to get here on this particular issue.
What do the cases say about timeliness? Don't they say it's not a factor in determining whether an adequate remedy is available?
It does. It does say that delay, and if I'm quoting correctly, delay alone is not. However, that delay has caused my client to incur thousands and thousands and thousands of dollars of attorney's fees, where you have the state who is, not subject to those constraints. You've also got.
But wouldn't that be the case in any case that's been delayed, and there might be, in essence, for lack of a better term, an interlocutory appeal, as in this case?
I believe this goes further than just the delay and the increase in the attorney's fees that have come about because of that delay. And that is that, not just because of the delay, but also because TDEC has attempted or, did appeal a final order, which they are prohibited from doing under the Water Act, that violates Jamesway's due process rights. They have a lack of a fair hearing. We talked about, Mr. Kilgore talked about that Jamesway can get the same relief in front of the board as he could, essentially the relief we're seeking here. The problem with that is that the board does not have the authority to hear procedural issues.
But that's not what the statute, that the judicial review statute talks about judicial review of the final agency decision. It's not about what relief the board can grant.
Sure.
It's about whether judicial review of the final agency decision provides an adequate remedy. So you could still take it up, get judicial review, get a court to say that, TDEC's petition was untimely. So why is that not an adequate remedy?
And I liked your question earlier about what is an adequate remedy. I
was going to ask you that too.
I really hadn't
feel
thought
free to
about that
weigh
until
in.
and I was like, well, I haven't seen any case law that defines, quote, adequate remedy. But I think that takes us back to the same considerations of lack of due process or violations of due process, along with the
What,
delay.
I'm not sure I understand your due process argument. Could you?
Yeah, what are the due
articulate that?
process rights that were violated here?
Sure. It requires that potential litigants be provided an opportunity for presentation of claims at a meaningful time and manner. And we've certainly not been able to get that within a meaningful time. We've been here 7 years and just have gotten to this point, which is not even the merits of the underlying issue.
Well, that doesn't, meaningful time, I mean, that doesn't mean that you should be able to get a decision on the timeline that you want. I mean, that's about whether, delay in getting a decision would cause some sort of, kind of going back to the discussion about irreparable harm. I mean, there are certain kinds of things, privilege, for example, as Mr. Kilgore, I think, referred to. I mean, there are certain kinds of things where if you don't get immediate review, your opportunity to have that claim addressed in a meaningful way will be altogether lost. If the privilege documents are disclosed, you can't unwind that, right?
Sure.
You can't pull them back. This is a very different situation to me, and I really am, I am struggling to see how, if you can't tell by my questions, I think really struggling to see how there is any kind of, judicial review of the final agency decision wouldn't provide you with everything that you would want in this case, other than, wanting it to happen a little faster.
And I think that goes back to the question of what is an adequate remedy. And, there was a discussion with Mr. Kilgore about, do you have to show irreparable harm for that to be considered an adequate remedy? And I agree with him that I don't think that, certainly in that case, and I believe Justice Kirby, you were the one that posed that question. And I'm sorry, I lost my train of thought there. But going back to what Mr. Kilgore says, I do believe that that it's not just the irreparable harm, while that might be a consideration, it's not the sole consideration, and I don't believe that we can equate irreparable injury with adequate remedy.
Let me frame this a little bit differently.
Sure.
Your client obviously wants to avoid the expense and the effort involved with continuing with the administrative proceedings. Are there other practical effects on your client if they cannot get the case dismissed based on a lapsed deadline at this point?
Other than the due process.
Use of their property or anything else associated with the substance of the dispute here?
No, because it was not Jamesway's property that this.
Right.
Yeah, that the materials were left in.
I'm
right.
just giving an example.
Sure. And that's a good question. I haven't really thought about that either, other than that the judicial review of the final agency decision would not give Jamesway an adequate remedy, because we would have to, especially at this point, as far as we are in this part of the litigation, again, 7 years, if we had to send this back down, go over a week-long trial, and then start the appellate process all over again, I think that's a consideration as well.
But isn't that just time? That's time and money, correct?
Yes.
Okay, well, would you agree that there are some cases, as we're talking about what is an adequate remedy, there are going to be some cases in which there is no adequate remedy, in some cases in which there is not, correct?
Correct.
Okay, wouldn't every case in this similar posture include a time factor, a cost factor, and an argument that due process rights are violated? How is this case different from any of those cases that might be in a similar posture?
And going to the interlocutory appeals, certainly there are cases where an interlocutory appeal is granted. And we look at, the factors for granting an interlocutory appeal, such as, judicial economy and public interest.
But are you taking the position that the definition of adequate remedy should be essentially equivalent to the factors of Rule 9 interlocutory appeal?
I don't think we can cap them at that, but I do see some similarities in the considerations. Not that those should be the sole considerations, of course, because every case is at least a little bit different, right?
Well, that's what I'm trying to focus on here, and I want to go back to my original question. I want you to identify for us how the situation with your client differs from any other client that would be in a similar situation when you've had a 7-year delay. You're going to have additional costs, including attorney's fees, if you have to go back, and that you've had alleged violations of due process rights. How is your client different from any other client that would be in that same position?
And I'm not sure if this is exactly answering your question, Your Honor, so I may need you to clarify a little bit after I start here. But one of the reasons that Jamesway, or that judicial review of the final agency decision would not be an adequate remedy is that TDEC is not allowed to appeal final orders. Not just, which deadline applies, but although those kind of weave in together. But I do understand your question about, cost and delay, but we also have other considerations as well, such as, judicial economy, the fact that.
But judicial economy would be the same with any other client.
Sure.
That would be in the similar position to you, correct?
Sure, of course.
So let me ask you the same question that I asked your opponent. If the floor, if you will, is not irreparable harm, if you don't have to necessarily show irreparable harm in order to say I don't have an adequate remedy, in deciding cases, we often have to articulate reasoning, limiting principles. How would you, if the limiting principle is not, okay, unless there's a final decision, you have to show that you have irreparable harm. And you're saying, no, it's not that strict. So how would you articulate an appropriate limiting principle?
I do believe that, in addition to the other factors we've talked about, just such as, delay and the burden of increased cost, judicial economy, is there's a fairness component to that as well. I don't know that I can give the court a book-ended definition of adequate remedy, because I do think that there are a lot of considerations in play. But you do have, in this particular case, the TDEC trying to exceed its agency authority.
So, counsel, if I could follow up on particularly Chief Justice Bivens' questions. So we have an order, a preliminary order, and the issue is whether this court has subject matter jurisdiction for review. Okay, so let's assume that you went to trial in this case and you had a final agency decision. So asking Chief Justice Bivens' question a little bit differently, what's the difference? What is inadequate about our review of a final agency decision as opposed to our review today? Would we not actually be in a better position to review the case on a complete record?
Not the issue that we're here about today. about which statute, which statute controls.
It's going to be there, it's there now, and it's going to be there then, right?
Sure. And I do agree to some extent that the issues are going to be the same, but the difference is whether or not waiting or making Jamesway go through a needless trial before this decision is made about which statute controls, it's just a further burden on our client, just like in any other interlocutory appeal where, you tell the judge, like, Your Honor, this is going to be an increased burden on our client. Let's go ahead and get this issue settled before we go on to the merits of the case.
But this is not like any other interlocutory appeal, is it?
I understand the similarities, but no, answering Justice Bivens' question, I don't believe that it would be the same standard because we're given the text or the term adequate remedy. So you have here that TDEC is trying to exceed its statutory authority by not only using the wrong deadline, but we also have, they're appealing a final order, which they're not allowed to do under the statute of the Water Act. So it just seems that Jamesway is in a position that if this matter could be decided now, rather than having to wait for an agency level decision, that would, I can't say unburden our client, but because our client has certainly been overly burdened considering just the length and the number of appeals in this case and the fact that the agency hasn't tried to increase its authority. But we also have the fact that, I keep going back to that adequate remedy language, which I'm glad Justice Campbell brought that up because I had not thought, well, what is an adequate remedy? The cases don't come out with a clean definition that I've seen, but there are considerations that, cases talk about. So I'm not sure, did I answer your question, Justice Tarwater?
You did answer the question.
Okay. Jamesway also made the argument that even if the court has subject matter jurisdiction, we do believe that the issue is now moot, considering that the Water Act was appealed and that we've always maintained.
Was that retroactive?
I don't believe it was retroactive.
Okay, so how would that moot the issue in this case then?
I believe the case is still ongoing, so there hasn't been I could understand if there had been a final determination, all appeals exhausted, you would not be able to go back and resurrect. We don't believe that there was any wetlands on the property, and which the board agreed with.
But we have to look at what law governed kind of at the time of the underlying events.
Sure.
To determine whether a later statutory, the statutory change that you point to was not, my understanding is it was not retroactive, it would be
And I believe
prospective.
you're correct, Your Honor.
Okay, so would you concede then that change does not affect the justiciability of this case?
It may not decide the issue of whether or not it's a wetland, but it doesn't decide the other issues in the case, such as, past, are you talking about just for the mootness doctrine?
Right, I'm just asking about your mootness argument.
Right.
I think, doesn't that defeat the fact that the change to which you point was not retroactive, doesn't that necessarily mean that your mootness argument fails?
And I want to make sure I'm answering your question correctly. Because, of course, who wants to concede points, right?
Right.
But I do understand about that, it's not a retroactive statute. But you still have the same, we still have the same issue of whether or not it was a wetland even before the statute changed. But I understand that would be an underlying merits determination. But here, I think that even though the statute is not retroactive, that the court can, or the administrative law judge or the board can take that into consideration.
And in what way?
I think they can show it as, how the legislature has, how the legislature is leaning in that situation.
Well, I disagree with you on that, but in any event, that wouldn't mean that the issue is moot, correct?
Correct.
Okay.
Yeah, I mean, how can it help you in that regard? Because if the legislature is changing the statute, would it not indicate that they had a different interpretation prior to the amendment to the statute?
I believe it clarifies what was in that statute. It did break down the different types of wetlands. It states, specifically what individuals or entities can be penalized for and what they cannot be penalized for. And I'm sorry, your question again was, how was that?
You seem to be arguing that the fact that the legislature amended the statute, even if it's not retroactive, in some way supported your argument
Oh, and
in interpretation of that. And my point was, isn't it to the contrary, that the fact that they've amended that statute would indicate that at least their thoughts were that that the courts or the agency or whomever were interpreting the prior statute very differently than what they wanted in the new statute.
And I believe, and like I said, I believe the amended statute clarifies and also adds, it does add a new section, I believe, but it just clarifies what the intent of the original statute said as far as the definition of a wetland.
If we get to the substantive issue on the deadlines, I'd like to hear you address why we should not consider the portion of the statute that was not actually put into the code.
The uncodified statute. And we've included in our brief that in the 2013 Public Act, there's directory language for items section 1 through 18. And, they say things like, this statute shall be amended to delete this language and to add this language. And then you see that in 1 through 18. You do not see that in 19. Both parties have cited that the legislature knows what they're doing when they pass laws. And it seems that if the Tennessee Code Commission could not have included that in a codified statute, considering that there is no directory language or enacting language stating where this even appears in the statute. Also, it would all conflict with the other, there's more than one statute in the Water Act that says the UAPA governs. Let me pull that up. We have 69.3.102D that says it's intended that all procedures in this part shall be in conformity with the UAPA compiled in Title VII, Chapter 5. But we also have then the 69.3.120, which says that if any provision of this part conflicts with the UAPA, then the latter shall govern. There's a sort of a mirroring statute in the UAPA, which says the same thing. I don't believe we get to, I know TDEC has raised the issue of, there's a question, I guess, on their argument whether this is legislative intent or legislative history. In the trial court, they took the position that it was just mere legislative history or legislative intent. Chancellor Martin disagreed, Chancellor Martin actually agreed that it is legislative intent or legislative history, and that based on the unambiguous language of the face of the statutes, that you don't get to consider that. You have to look at the clear and plain language of each individual statute. And clearly one says, or both acts say that
My question goes to, why should we not consider the portion of the statute that was enacted by the legislature but not put into the code by the Code Commission?
I don't think it could not have been put into the code by the Code Commission because there is no directory language even stating where this provision is supposed to be in the code.
So
or whether it's even supposed to be in the code.
So your position is that it was part of the enacted statute, but the legislature could not have intended it to actually become statute?
Yes, Your Honor.
Even though the legislature passed it and the governor signed it, just like any other act.
Yes. If the legislature had wanted to actually amend the statute to include Section 19, then they would have. But they did not include this directory language indicating that it actually, amends the current statute.
But how is that relevant as to whether that language has the force of law, whether it is law? I mean, our Constitution prescribes the procedures for something to become law, and those procedures were satisfied with the enactment of the legislation, were they not?
I'm sorry, say that one more time, the last part.
Those requirements for lawmaking, the constitutionally prescribed procedure for lawmaking, I mean, all of those requirements were satisfied when this act was enacted and signed by the governor, correct?
Correct.
So, I mean, why is whether it was codified or not, why is that even relevant to whether it still is the law when we're interpreting the law?
And I guess the question then would become, where did the legislature intend this provision to be in the statute?
Well, but I mean, I think you're sort of presupposing, that argument kind of presupposes that what is the law is what is in the code, what's in the green books that,
Sure.
we pull off the shelf for, when we go to Westlaw and search the Tennessee Code annotated or Lexis. Equal opportunity. But that, I mean, it's a bigger question, right? What is the law? Like that is a big question, but the Constitution doesn't say anything about codification. What the Constitution prescribes, are the requirements for, the legislature to make the law. And all of those requirements were satisfied here. And so, set aside, I guess, whether the legislature thought about where it would go in the code. I mean, the question here is, is it law?
And I
So
think-
why does, whether it goes in the code or not have any bearing on that question when all of the constitutionally prescribed requirements for lawmaking were satisfied as to that language?
And I believe one of the keys here is talking about Article 2 of the Constitution, Section 17, which says, all acts which repeal, revive, or amend former laws, which TDEC is arguing that this amended a current statute, they shall recite in their caption or otherwise the title or substance of the law being repealed, revived, or amended.
So you're really hanging your hat on that argument, so you would push back then on the assumption that all of the constitutionally prescribed requirements were met. So does your argument really turn on that argument about, specifying, what it amends, and not on whether it made its way into the code?
It also turns on another argument as well. TDEC raised, that the, sort of hangs their hat on the dissent, saying that there are, even if there's a codification error, it still remains law. However, the cases that Judge Usman, okay, thank you, cited, those were errors during the codification process. This is not where the Tennessee Code Commission did not follow how the act was written by the legislature. So we do have that. We also have, that the Code Commission does not have the authority to codify a statutory amendment when the General Assembly itself has not provided what statute that's going to be amended.
Do you have any insight on the reenactment provision that I asked opposing counsel about?
Are you talking about
TCA 1 to 114?
Could you tell me, I had not been prepared to speak of
That's okay.
that, but when you did mention it.
Yeah, if you weren't familiar with it,
did
it's not
ring
worth
some
discussing.
bells. But can you tell me again what that statute says?
I don't think it would be a productive discussion if you haven't
Okay.
had a chance to really look at it, but I was just curious. Thank you.
I see that my time is about out. So I will just wrap up with saying that, we believe that based on clear statutory construction, that the UAPA controls the deadline on which the appeal should have been, or the deadline on which any order should be appealed. We don't believe that TDEC followed those rules, that TDEC actually appealed a final decision, which it is not permitted to do per statute, and that in the interest of not just judicial economy, but also overly burdening our client, the lack of due process, that Jamesway will not get an adequate remedy by sending this back to the administrative court to have a hearing on the merits and then sent back here to decide those issues. Thank you.
All right, thank you. Mr. Kilgore?
Thank you. Just a couple of points on rebuttal. I did not hear my friend on the other side dispute, and I believe that she may have agreed that on judicial review of a final agency decision, in this case, Jamesway can obtain the exact same relief. And Jamesway has still not otherwise articulated particular circumstances that would frustrate or render that relief inadequate. Jamesway points to the 7 years that this litigation has gone on, but jurisdiction is assessed at the time that the PFR is filed. And so in this case, that at least cuts off 3 years of those proceedings. My friend on the other side has pointed out that we've proceeded all the way to the Tennessee Supreme Court on this issue, and then there's a chance that we may have to go all the way back down. But I actually think that that cuts against Jamesway's argument, because that's one of the reasons that interlocutory appeals are disfavored. I think, Justice Tarwater, you pointed out we would all be in a better position if, instead of having this issue, which ultimately may result in having us to go back down and redo the merits and then proceed, we could have a tight package in which all of the issues are in front of the court in a single hearing. My friend on the other side also says that TDEC can't appeal from final orders, but of course that is the merits to question here. And I would also just point out, in terms of judicial economy, that the briefing at the board stage has already completed. The PFR was filed after TDEC filed its reply brief on the merits to the board, and that is currently stayed pending decision in this case. I'd also like to say that this case is not moot for all the reasons Justice Campbell and your colloquy with my friend on the other side pointed out. The lack of retroactive effect of Chapter 437 renders the mootness argument, means that the mootness argument fails. And then I would also just like to point out that there would be serious implications if codification was the end-all be-all as to whether or not a statute is law. As Judge Usman pointed out below, that would have serious constitutional consequences. It would essentially it would allow the Code Commission to operate as kind of a roving General Assembly and governor all in one. They would be able to amend, change, and alter statutes, notwithstanding the fact that they are statutorily precluded from doing so. I think it's also notable that I looked back, the Code Commission, which is itself a creature of statute, the first instance of statutory authority that I could find of it was in 1953. So if the Code Commission didn't exist before 1953, presumably my friend on the other side would claim that Tennessee had no law prior to 1953, before the code was enacted. And I think just the last summary, I know that there's been a lot of discussion in trying to assess what qualifies as an adequate remedy. And in reading all of the cases, I think it's fair to say that the key inquiries focus on whether final review can provide the same procedural protections and substantive relief as immediate review. Courts examine whether issues can be preserved for final review, whether the same standing requirements apply at the interlocutory appeals and on final review, whether identical relief is available, and whether the same review standards govern both intermediate and final review. And we submit that in this case, because Jamesway can obtain the same relief on the same theories in an identical challenge, that is an adequate remedy on final judicial review. And so we would ask that this court vacate the decisions below and remand this case to the agency for further proceedings. If there are no further questions, thank you for your time.
Thank you, Mr. Cool. Thank both counsel very much for your arguments here today. All right. Is everybody okay? Go ahead. Everybody okay? Go ahead. All right. Mr. Clark, if you'll call the next